As a wedding photographer, have you ever had a client tell you last minute that they need to reschedule? Or what about a client who has asked you to change your photography coverage hours 3 to 4 times, and now they're not even issuing you your full payment prior to the wedding date? Or what about if you're a photographer who has been harassed by wedding guests or the wedding party itself? If you answered yes to these questions, and maybe you answered no, but trust me, these things can and will happen, then you need to ensure that you have these 6 really important clauses in your wedding photography contract to protect you and your business. Clause number 1 is a cancellation by clients clause. Cancellation clauses are pivotal to ensure that you get compensated in the event that your clients cancel the contract and your services prior to your coverage date. Now, if your clients are canceling their wedding, there are probably some high emotions running. So you want to ease into that conversation gently, but that doesn't mean that you have to roll over. You absolutely deserve some type of compensation for reserving that date on your calendar well in advance. First and foremost, this clause absolutely needs to state that in any event your client cancels, the retainer will not be refunded to them. This retainer is the amount that you took for reserving that date and putting an X on your calendar well in advance, like I said, 6, 12, 18, 24 months in advance, whereby you couldn't say yes to any other clients that inquired. Then your cancellation clause should have something regarding a time limit for canceling. For instance, say your clients cancel 90 days in advance, then they probably wouldn't be obligated to pay any remainder of the amounts due under the contract. Usually, your notification time limit in this clause is around 30 to 60 days. Most photographers state that if their clients cancel within 30 days, that the retainer won't be refunded, but they won't be charged any additional amounts due because they can probably mitigate damages and try to book some other services on that date. But if your client cancels within 30 days and even within a couple of weeks of the wedding, then you're out a lot of money. It's probably almost impossible for you to book that date again on your calendar. So they might be obligated to pay a portion or all of the remainder amounts due under your contract. The one big thing legally to remember here is that sometimes you can say that you would obligate them to pay this under your contract, but in reality, if you were to ever have some type of legal debacle go down and your clients took you to court, it would be really difficult to get any amounts paid to you for services that you did not perform. So oftentimes you really look like the good guy here because you're only just going to keep the retainer from them and you are not going to try to get any other form of payment for them when they cancel. But like I said, because this is your contract and you want to try to avoid your clients canceling at all costs really close to the event date, then we suggest that you have at least a 30-day notice provision in there for your clients to cancel. And if they cancel within 30 days, that all remaining payments are due in full. The questions I get here are, Paige, what happens in the event my clients do cancel within those 30 days and I'm trying to get any type of remaining payments from them and they are refusing to pay me? If they are refusing to pay you, then you have a few options here. First, you could take them to small claims court for a contract breach. Now, this is probably an uphill battle because you didn't render any services. However, your service contract is there to protect you. You have lots of arguments on your side that it would be virtually impossible for you to book another wedding date on your calendar on that same date that they're canceling if they're doing it within 30 days, because people have their vendors booked out months and years in advance. Not to mention, your client agreed to the terms of your contract, and you probably pointed out your cancellation clause prior to them even booking, so they knew about this policy. And this leads me to the second option, which is you could give your clients a one-time courtesy and relieve them from any remaining payments under the contract. Sometimes this is just a better route because it can lead to your clients wanting to work with you sometime in the future and possibly even a really good review. Additionally here, if you have the terms non-refundable and non-transferable retainer under your cancellation by clients clause in your contract, then you absolutely will at least be able to keep the retainer and you won't be out all of the money and having to refund it. All to say, whatever option you choose, please make sure your cancellation clause is solid in your wedding photography contract. Oh, and it's important to note here that if your clients do end up canceling, you need to do something with the original contract. I suggest that you make sure your clients sign a cancellation contract, which essentially rips up and terminates the original contract and includes all of the terms of the termination or cancellation by your clients. Clause number 2 that you need to have in your wedding photography contract is a rescheduling by client clause. Now, a rescheduling clause has been basically the most essential clause to have in your contract since the COVID-19 pandemic started. We knew that we needed to have rescheduling clauses in our contract before that, but man, do we know now that that is literally probably the most critical clause in your contract. To sum up what really happened in 2020 was that vendor contracts for weddings and events were really kind of confusing or very unclear what would happen in the event that someone would need to reschedule or a force majeure event such as COVID-19 occurred. And so couples and vendors were working together to try to navigate this issue because their contracts weren't very clear on this. And ultimately, vendors were having to give reschedule after reschedule after reschedule for free. So I don't want you to do that. And this is what you need to have in your rescheduling by client clause. The first option is to give a one-time complimentary reschedule to your clients. If you want to do this, then you need to explain the provisions of that type of complimentary reschedule. This is going to include something regarding the time frame for rescheduling, that you will allow a reschedule to occur one time, not more than once, and that one time has to happen within, say, 6 months or 12 months of the original date. This is important because wedding vendors, especially photographers, often increase their package prices year after year. And so you don't want to be held to the same package price that you were in, say, 2022 that you obviously don't charge, say, in 2024 if that's when your clients want to reschedule. This also prevents people from dragging their feet, so to speak, and obligates them to get that date on your calendar booked as soon as possible. And it gives you kind of a release and kind of weight off your shoulders if you were just waiting and waiting and waiting and going back and forth and communicating with your clients time and time again to figure out when they're going to reschedule their wedding date. A hot tip here is that if you do choose this option and you want to give your clients a complimentary reschedule, then you need to send them emails. If they aren't rescheduling any date on your calendar, say within 6 months and 8 months and 10 months, this will keep a paper trail via email documentation to ensure that you have indeed notified them that they need to reschedule with you. Another option is to reschedule but with an additional fee. This is usually what photographers across the board, I would say a majority, like 90% of photographers go this route. Because you of course want to allow your clients to reschedule, but there's an opportunity cost there for you where you already booked that date on your calendar well in advance for these clients, and now they not only had that date on your calendar reserved and you probably aren't going to be able to book anyone else on that date for the majority of circumstances, they are also asking you to reserve another date within 6 to 12 months on your calendar. And with that comes a fee. Rescheduling fees usually are around $500 to $1,000 minimum. The reason being is you really want to try to get your clients to avoid rescheduling. You want a hefty enough fee so that they don't feel like, oh, it's an easy thing to reschedule with you. And I still recommend with this option that you require them to reschedule within a certain time period. Again, usually 6 to 12 months. And the final option here is to simply not allow rescheduling whatsoever. That if they decide to reschedule, it's essentially deemed as a cancellation or termination of the contract All fees paid, including your retainer, are going to be kept by you and non-refundable, and that they would need to book another contract with you with a totally new retainer and totally new payment system for their new rescheduled date. The key here is to make sure that no rescheduling is very clearly laid out in your rescheduling by client clause. If you choose this route, I recommend that you bold or capitalize this clause and all of the provisions of this clause in your contract, and even potentially have your client's initial next to it so you know and they know what your rescheduling policy is, which is no reschedule. Clause number 3 that you want to have in your wedding photography contract is a harassment clause. Speaking of taking care of your well-being and protecting yourself, you definitely want to have this type of clause in your contract. I like to say point blank, this is a non-negotiable clause in your contract. If your clients want to take out this clause, then you absolutely should be thinking twice about working with them and should probably run as fast away from that client as possible. Your clients should absolutely want to protect you as a service provider on their wedding date. We all know that weddings can get wild and there can be lots of alcohol and potentially open bars. And when alcohol is involved, people can get inappropriate. I can almost guarantee that any wedding photographer who has been shooting for at least a few years has been harassed in some way, either verbally or physically. And so you should have an option to take action and leave and terminate your coverage immediately in the event you are harassed. And that's exactly what this clause needs to say. Period. End of story. The legal page offers a few different options for a harassment clause. The first is a 2-strike rule, and we are pretty accustomed to seeing this in wedding and event contracts. Essentially, what it states is that if you, as the service provider, were to get verbally or physically harassed, that you would give a first notice to your clients that this is occurring, and then they would have to take the necessary steps to try to either make that guest leave or to, make sure that the situation doesn't happen again. And if it does happen again, or if you continue to feel very uneasy being there as a service provider, that you immediately then could terminate and leave the event. But in my experience, after seeing what is played out in the wedding world, I never recommend a 2-strike rule, especially for female photographers. And here's why. You should never have to subject yourself to more than one type of harassment situation. Any harassment is not okay, verbally or physically. Thus, a 1-strike rule under your contract, under a very clear harassment clause, would notify your clients well in advance that if you did get harassed at the event that they are hosting, that you could terminate and leave immediately. Of course, the big thing here to remember is this is just the actual language in your contract. Some situations that are very egregious would absolutely justify you terminating and leaving the event immediately. But if you, as the service provider and the person who is getting verbally or physically harassed in some way, do feel that you could notify the clients and give them one last chance before you did leave to try to mitigate the situation in totality, then you absolutely have the right to do that. But I never want you to put yourself in a position where you're obligated to notify your clients if the harassment is really affecting you and it is really, really severe. Okay, moving on to the next clause. Clause number 4 that you absolutely need to have in your wedding photography contract is a model release clause. This clause serves as a release, giving your business the full rights to use images of your clients in all advertising and trade and promotion purposes. This clause is important because you want to be able to share all images of the wedding and of your clients and of their guests on your social media and website without hindrance. However, you cannot do that just automatically. You have to have your clients say yes to you using their likeness and images of them for your marketing and advertising. Clause number 5 is a copyright clause, whereby you are only giving your clients the ability and license to use the images for personal use only. A copyright clause states that you are the owner of the photographs under federal law. This clause is really important because oftentimes clients think that when you send them their images, usually via an online gallery, that then they own the copyright to the photos and can do whatever they want with them and can share them with any third party that they want, including vendors. However, that's not the case. You want to ensure that you continually own the copyright to your images, which is the legal right and ownership of those images, and that your clients, you're just assigning a limited right for them to use those images for their personal use. I never suggest assigning full copyright ownership over to your clients unless they are celebrities or government officials of some sort and they pay a very hefty price for the full copyright ownership, because then you cannot gain any compensation or royalty payments afterward if you have assigned all of your copyrights to them, because they're the now legal owners of all of those images. Something you'll want to clarify with your clients, and especially have in the language of your copyright clause, is that they can use it for their personal use for printing purposes and sharing purposes, so that your clients feel that they absolutely can share the images that you took of them on their own social media accounts. And finally, clause number 6 is a meals and breaks clause. This clause is absolutely essential in the wedding photography world, and here is why. You are working long hours. You're working 6 to 8 to 10 to 12 or more hours in one day. You absolutely should be guaranteed at least one meal, if not more, that your clients are giving to you, or that your clients allow you to leave and not complete full services within 6 or 8 hours and give you a little bit of time to go get a meal. Say if they don't give you a meal, then you can have a 20-minute break to go eat your meal or go get something somewhere nearby. Also, you deserve adequate breaks. Your clients can't expect you to be shooting photos the entire time for, say, an 8-hour wedding day. Thus, in your contract, you want to ensure that you have at least 1 or 2 meal breaks, explain how long those are, and that you will probably have to take at least a rest or a bathroom break for 10 minutes every couple of hours. A hot tip here is that in your meals and breaks clause, as a wedding photographer, I always suggest you put that you like to eat when the wedding party eats. That way, you are still capturing all of the essential reception events and things that occur, but you're not necessarily going to be needed to take photos of the wedding party eating, if you know what I mean. Oh, and make sure you're subscribed to my channel because I'm actually going to be releasing an entire video here on YouTube soon about a meals and breaks clause and how to best utilize and invoke this clause during a wedding day. You know that you need to cover all of your bases as a wedding photographer, and I am here to help you do that. I just described 6 really important clauses to have in your contract, but that is not all of the recommended clauses that I want you to have in your wedding photography contract. If you want the full list of all of those clauses, I have a free checklist for you in the description of this video below that you can get right now. Oh, and over at thelegalpage.com, we have the most comprehensive full-length wedding photography contract that has been reviewed, critiqued, and used by thousands of wedding photographers. This contract will cover you if your clients don't pay on time, if your clients ask you for extra coverage day of, and what that looks like and entails, and if your clients come back 3 years later and ask you to unarchive photos on your hard drive in your safe that are no longer online for them because they didn't follow the instructions of downloading. Of course, it includes much more, and I want to ensure that you don't get caught in any sticky situations with clients because wedding photography is just one of those things that things happen, and you want to be prepared for all of those what-if situations. I highly encourage you to check out the Ultimate Wedding Photography Contract, and the link here at the legal page is below in the description box. Bye now and see you in the next video.